This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. All right, so there has been a major update in file sharing copyright trolling lawsuits, and I'm sorry, it's not going to be the kind of update most people want to hear. You may remember we reported last year that in several cases, Judge Royce Lamberth in the DC district and Judge Joel Schneider in New Jersey, and one or two other judges sort of took action against Strike 3 Holdings, either denying them access to the court altogether, in Judge Lamberth's opinion, or denying subpoenas to defendants who are anonymous, and so you need to get a subpoena to get the defendant's identity, or else how do you know who to sue? And that's really what this is all about. When a copyright owner sees infringement in the form of file sharing on a BitTorrent-based network, or swarm, as the courts call them. I don't really like that term, but it works. So a BitTorrent file sharing swarm, and they can record all of the IP addresses that are associated with that swarm and with the file that's being shared, their file, their video in this case. Can the plaintiff obtain a court-ordered subpoena for the identity of the subscriber to the internet connection that allegedly was seen being used to commit the copyright infringement? We don't know if the subscriber is the infringer at that time. We don't have anything more, something more than that from the Cobbler, Nevada case. The Ninth Circuit Court of Appeals said you needed something more than just the IP address and evidence of infringement. But that something more was tied to the end liability at the end of a trial or a summary judgment motion, not super tied to the beginning of a case where we're trying to uncover the alleged defendant's identity. So this case now, Strike 3 Holdings versus John Doe in DC, and another similar one in New Jersey, and a bunch of thousands of other cases around the country, but these two went to an appeals level. The New Jersey case only went to the district level from a magistrate judge, so that's not really that great of a, that's authoritative in New Jersey, but persuasive everywhere else. This is going to be a appeals court opinion, but it's only for the District of Columbia, for Washington, D.C. But an appeals court opinion, like that Ninth Circuit Cobbler, Nevada opinion saying we needed something more, the appeals court opinion is going to carry weight. Even if it's not precedential outside of D.C., it will carry weight. Very much like it is precedential. It'll be very persuasive. So let's take a look at what we can learn or garner from this lawsuit, because I think we'll be able to find a lot inside here that we can learn from. So this is again for the DC Circuit Court of Appeals. This is Strike 3 Holdings, of course, versus John Doe. This is the first Strike 3 Holdings appeal ruling. And here are our players. We know who Lincoln Bandlow is, and I don't know who Jessica Fernandez is, but Emily Kennedy has been handling these kinds of lawsuits from the beginning, and there's great suspicion that she's really the brains behind all of this. Lincoln, of course, has taken a lead role as well now. And this is an opinion for the court by Judge Rao. I don't know if that's the correct pronunciation, but I'm going to pronounce it Judge Rao. Strike 3 Holdings LLC is a producer and distributor of adult films. This case arises out of a copyright infringement suit filed by Strike 3 against a John Doe defendant alleged to have illegally downloaded and distributed Strike 3's films. In its complaint, Strike 3 was able to identify the defendant only with an IP address, linked to numerous acts of online piracy. Strike 3 could not identify the defendant and effectuate service without subpoenaing the defendant's internet service provider, and so moved the district court for a court order under Federal Rule of Civil Procedure 26. The district court denied the Rule 26 motion and dismissed Strike 3's complaint without prejudice. While district courts enjoy substantial discretion with respect to discovery matters, that discretion is not unbounded. We now hold that the district court abused its discretion by assigning improper weight to what it viewed as the aberrantly salacious nature of Strike 3's films, by concluding that Strike 3 could not state a plausible claim for infringement against the IP address subscriber, and by drawing unsupported negative inferences against Strike 3 regarding its litigation tactics. You remember how happy we were that Judge Lamberth used such strong language against Strike 3 Holdings? Well, now that language has been ruled to be too strong, and maybe even showing some kind of bias or improper inference against the plaintiff. We therefore reverse the district court's order and remand for further proceedings consistent with this opinion. Strike 3 distributes films through various websites and owns the copyrights to the motion pictures distributed under 4 different brand names. According to Strike 3, its websites receive more than 20 million unique monthly visitors, and tens of thousands of subscribers pay for its content. Like many film distributors, however, the company also faces rampant online piracy. In an effort to combat illegal downloading and distribution of its films, Strike 3 has filed thousands of copyright infringement lawsuits in district courts around the country. These lawsuits follow a consistent pattern. Strike 3 works with a third-party forensic investigator to monitor the BitTorrent peer-to-peer file-sharing network for the presence of Strike 3's copyrighted works. Utilizing forensic software, the investigator can record a specific IP address engaging in a specific act of infringement at a specific time. Once an infringing IP address is identified, Strike 3 uses geolocation technology to determine where the registered subscriber of that IP address is located. Armed with this information, Strike 3 files a copyright infringement lawsuit in the appropriate federal district court, naming the John Doe subscriber of the offending IP address as the defendant. Note that this case was filed and all this happened before the Florida Pure Bill of Discovery nonsense that is going on now, where Strike 3 seeks this subpoena in Florida. Now, what do you think that was for? I think that was a very clever attempt. It's been a success now, right? So I think that was a clever strategy to insulate Strike 3 Holdings and their lawsuits against exactly this ruling if this ruling had gone against Strike 3, because this ruling would have foreclosed their federal court subpoenas. Now they have found a state court that will give them the same subpoenas. Actually, will give them even easier and better subpoenas because they can file multiple defendants in one lawsuit. So one $385 fee, I think it is in Florida, and they get multiple defendants, sometimes dozens or even 100. And those lawsuits end up being 700, 800, 900, 1,000. We've had 1,100 page lawsuits from Strike 3 Holdings in Florida using the Pure Bill of Discovery tactic. Using the technology described above, Strike 3's investigators recorded an IP address illegally distributing Strike 3's films via BitTorrent networks on 22 separate occasions over the course of approximately 1 year. Strike 3 determined that this IP address is registered to a subscriber located in the District of Columbia. In June 2018, the company filed a complaint against the IP address subscriber in the U.S. District Court for the District of Columbia. Because internet service providers are the only entities that can link an IP address to its subscriber, Strike 3 could not serve its complaint without first subpoenaing the subscriber's ISP Comcast for information identifying the anonymous defendant. Accordingly, the company also filed a Rule 26 motion seeking leave to subpoena Comcast for records identifying the John Doe IP address subscriber. Normally, they don't have to ask for permission for a subpoena, but because we're literally out of order, you're out of order. This is out of order. You're not allowed to send a subpoena until after the Rule 26 conference. You can't have the Rule 26 conference until after you've served the defendant. You can't serve the defendant until after you get the subpoena. You can't send the subpoena until after the conference. So it's a Bescherian conundrum. In its Rule 26 motion, Strike 3 argued that it has good cause to issue this subpoena because its lawsuit cannot proceed without the requested discovery, and because it would be improper for the court to dismiss the claims before Strike 3 has had the opportunity to engage in discovery to learn the defendant's identity. Strike 3 further averred alleged, that it limits its infringement lawsuits to strong cases against extreme infringers who not only engage in illegal downloading, but are also large-scale unauthorized distributors of Strike 3's content. Note that they don't accuse them of distribution or contributory or vicarious copyright infringement. They accuse them of the direct copyright infringement only. But that seems to be enough because copyright statutory damages are really high, and Section 505 of the Copyright Act gives them the ability to ask for attorney's fees, and the Fogarty factors and the lodestar calculation mean those attorney's fees could be really high, even though they're limited now by the is it Rimini Street? Yeah, Rimini Street versus Oracle. Oracle versus Rimini Street, I think it was, or Rimini Street versus Oracle, which limited copyright damages to only certain categories. Finally, the company stated that it is mindful of the sensitive nature of the litigation and encouraged the district court to issue a protective order allowing the defendant to proceed anonymously. That didn't used to happen. Malibu Media especially didn't used to automatically ask for protective orders, although they would grant them. Strike 3 has always granted protective orders whenever I've asked, but it's never been automatic. Now I think it's going to be automatic, and I think that's going to be a good thing. The district court denied Strike 3's discovery motion, applying a multi-factor balancing test adopted by the Second Circuit in Arista Records. The district court found that Strike 3's need for the subpoenaed information was outweighed by the potentially non-infringing defendant's right to be anonymous, a privacy interest the court found especially weighty given the particularly prurient material at issue here. The court acknowledged Strike 3's lawsuit could not proceed without the requested discovery, but explained that Strike 3's flawed identification method of relying on geolocation technology and IP address tracking to identify infringers failed to give the court adequate confidence this defendant actually did the infringing. And that's my main argument, is even under this new regime, you're still going to be suing subscribers. Not every subscriber is the infringer. Maybe it's 50 or 60%, who knows? And that's not me going on record, I'm just speculating. But there's going to be some number. I don't think that number is symptomatic of a strong enough correlation between a infringing act and the subscriber of an internet connection. Now, maybe the court could say, that's fine, you subpoena the subscriber and then you find out who the defendant is and then you sue them if you can. If you can't, you can't. But if you can, you then sue them. So yeah, it's okay to name the subscriber first as the defendant. But they don't say that here, I don't think. Let's take a look. Let's see if that's what they say. In particular, the court emphasized the risk that someone other than the IP address subscriber or roommate may have been responsible for the alleged infringement. While the district court recognized that honest copyright holders might balk at its decision, which could curtail efforts to combat online piracy through direct infringement claims, it expressly cabined its holding to the exceptional circumstances of this case. The court pointed to two factors limiting its holding. First, the aberrantly salacious nature of Strike 3's films, which is the nice way of saying they're offensive films. And second, the legion pitfalls associated with Strike 3's tracking and identification of infringers. Given these high stakes, the court refused to accept the risk of misidentification and denied Strike 3's motion. But the court left open the possibility that a future copyright holder could obtain a different result by showing the court a method to identify infringers with sufficiently less risk of false accusations. The district court then explained that Strike 3's resulting inability to identify the defendant made effectuating service or prosecuting these cases impossible. Accordingly, it dismissed the complaint without prejudice. Throughout its opinion, the district court expressed skepticism towards Strike 3's motivation in suing the John Doe defendant. The court characterized Strike 3 as a copyright troll that has flooded district courts around the country with thousands of lawsuits smacking of extortion, and declared that it would not indulge Strike 3's feigned desire for legal process by overseeing a high-tech shakedown. Strike 3 filed a timely appeal. In the absence of a named defendant, we appointed an amicus to present arguments in support of the district court order. So the defendant apparently did not defend themselves because there was no defendant, right? Because the court did it on its own. So this isn't New Jersey where there was a defendant. This is DC where there was no defendant yet. So amicus has fulfilled that role admirably, said the court. So the court goes on. I'll try to skim some of this. Federal Rule of Civil Procedure 26 provides in part that a party may not seek discovery from any source before the parties have conferred, as required by Section F, except when authorized by court order. In cases involving as yet unknown defendants in which a plaintiff cannot serve its complaint, much less confer with the defendant, without obtaining identifying information from a third party, the only potential avenue is for discovery under the rule. A district court's discretion to order discovery, whether before or after the parties have conferred, is cabined by the general limitations on the scope of discovery. A party may obtain discovery only of non-privileged materials that are relevant to the party's claim or defense and proportional to the needs of the case. Courts are directed to assess proportionality by reference to several factors, including the party's relative access to relevant information and the importance of the discovery in resolving the issues at stake in the action. As we have repeatedly recognized, district courts have broad discretion over the structure, timing, and scope of discovery. Accordingly, we will overturn a district court's discovery ruling only in unusual circumstances, amounting to an abuse of discretion. At the same time, we must take care to ensure that discretionary choices are not left to a court's inclination, but to its judgment, and its judgment is to be guided by sound legal principles. Where a district court rests its discovery ruling on an improper factor, it necessarily falls short of this standard. In this case, Strike 3 contends that the district court abused its discretion by relying heavily on the company's litigation history and the content of its films, rather than the relevant legal standard under Rule 26 and 12. We agree and find that three aspects of the district court's analysis require us to reverse its decision. First, the district court relied on an improper factor by treating the content of Strike 3's copyrighted works as relevant to its entitlement to early discovery. Second, the court committed legal error when it concluded that Strike 3 could not state a plausible claim of infringement against the IP address subscriber, even if the requested discovery was granted. Third, the court drew unsupported negative inferences against Strike 3 regarding its litigation tactics and motivation in seeking the requested discovery. We take each issue in turn. We first consider Strike 3's argument that the district court gave improper weight to the content of Strike 3's films in denying its Rule 26 motion. The district court made clear that its assessment of the motion was informed by the adult nature of Strike 3's films. The district court analyzed Strike 3's discovery motion by balancing the parties' relative interests. The court assigned great weight to John Doe's privacy expectations in this case, reasoning that the potential impact of a false accusation on the defendant's personal and professional life would be dire in a case involving particularly prurient videos. Given these purportedly high stakes, which the court viewed as unlikely to appear in more typical copyright cases, the court held that the risk of misidentification was just too great to justify granting Strike 3 the requested discovery. The court emphasized, however, that its holding was limited by the fact that this case involved aberrantly salacious content. The district court suggested, in effect, that Strike 3's ability to defend its copyright turned on the content of its films. This reasoning is not supported by the relevant legal standards. Even assuming, without deciding that privacy interests have continuing relevance in a Rule 26 analysis, none of the cases cited by the district court suggest that privacy interests vary depending on the content of a particular copyrighted work. Nor has amicus identified any authority for the proposition that content-based distinctions bear on a copyright plaintiff's entitlement to discovery in general. To the contrary, as the district court correctly recognized, defendants have little expectation of privacy in downloading and distributing copyrighted content without permission. Okay, but wait, the court just overlooked the subscriber. The lower court said, we're worried about the innocent subscriber, and the appeals court just said, to the contrary, defendants have little expectation of privacy. But they're talking about an innocent defendant. Doesn't an innocent defendant who didn't distribute and download copyright content without permission still have an expectation of privacy? Yes, that's what I'm thinking, and that's what this is about. The mere fact that a defendant may be embarrassed to have his name connected to adult websites is not a proper basis to diminish a copyright holder's otherwise enforceable property rights. But they haven't shown it yet! They've only accused a defendant. We don't know whether the defendant is innocent or liable, innocent or guilty. We don't use guilty for civil cases. Innocent or liable. So how can the appeals court then say that we know so much that they are not innocent that we can give them the subpoena? They're using a motion to dismiss standard and ruling in the light most favorable to the non-moving party. There's no dismissal party moving here, but that's what standard they're using, and they're ruling as if strike three has made that showing here at the pleading stage. Yes, on one hand, they're allowed to make factual allegations that, if proven to be true, would show liability under the law on the part of the defendant. However, I think this goes into that mere conclusion territory where they don't have jurisdiction. They haven't made an accurate pleading. They haven't met the pleading standard because they haven't pled with sufficient specificity which defendant they're suing. That's my main argument, is that they haven't gone beyond the pleading standard. The court here seems to feel that they've already gone beyond the pleading standard. They have pled with sufficient specificity, and all they have to do is uncover the identities of basically every person using an internet connection, and then Strike Three Holdings will be able to make its case. So they're saying that if Strike Three, can find somebody behind internet connection, then they're allowed to continue to sue. And that sounds to me like the court is endorsing a giant fishing expedition. Amicus offers little substantive defense for the district court's focus on the content of Strike Three's films, choosing instead to downplay the impact the film's content had on the court's analysis. For those reasons, we hold that the content of the copyrighted work is per se or automatically irrelevant to a Rule 26 motion seeking discovery to identify an anonymous infringer. Okay, and that's fine. I kind of agree with that. I don't believe that the content should be analyzed and saying because we don't like your content. However, I don't think that's what the court was saying. I think the court here, the lower court, Judge Lamberth, was saying society is particularly embarrassed by that kind of stuff. And we usually do that kind of stuff in super private because it's not something society accepts. Society accepts stories about, a young person helping an old person fly their house to South America. Those are acceptable stories by society. Society does not accept those other stories that we're talking about here. Society doesn't want to see it. Society will accept that it will tolerate it. So it's acceptable in private, like it's a don't ask, don't tell policy. So I think the court is kind of over the appeals court here. I think the appeals court is seriously overlooking the sort of don't ask, don't tell policy about this kind of content. It is very embarrassing for some people. Strike Three also contends the district court erred when it found a Strike Three subpoena would not identify a copyright infringer who can be sued. Okay, we're getting closer to my argument. By the district court's account, merely identifying the IP address subscriber would not enable Strike Three to state a plausible claim against that subscriber. Rather, Strike Three would have to resort to far more intensive discovery machinations, sufficiently establishing defendant did the infringing. Because the district court believes Strike Three would have no prospect of surviving a motion to dismiss even if it learned the subscriber's identity, the court concluded that Strike Three should not be permitted to discover the subscriber's identity at all. This reasoning is flawed in two respects. As an initial matter, it misstates the relevant inquiry when a plaintiff seeks immediate court-ordered discovery to identify an anonymous defendant. Great, we're going to get clarity on what the standard really is. At this stage, the court is not asked to pass judgment on the strength of the plaintiff's allegations, but to determine whether the plaintiff should have the opportunity to name that defendant in the first place. It is well established that plaintiffs are permitted to proceed against John Doe defendants so long as discovery can be expected to uncover defendant's identity. That is precisely what Strike Three seeks here. The discovery necessary to reveal the defendant's identity and to begin litigating its infringement claims. This is not to suggest that the quality of a plaintiff's allegation has no bearing on a Rule 26 motion. As with all discovery requests, courts must look carefully to the complaint's allegations to determine if the requested discovery is relevant and proportional to the needs of the case. In AF Holdings, for example, we rejected a plaintiff's attempt to rely on Rule 26 to uncover the identities of hundreds of John Doe defendants with no apparent connection to the district in which the plaintiff had sued. Given the plaintiff could not make even a threshold showing of personal jurisdiction, there was little reason to believe that the information sought would be relevant to the subject matter involved in the action. In other words, if a plaintiff plainly has no realistic chance of successfully suing the defendant, we will not allow that plaintiff to abuse the discovery process by seeking irrelevant information. But the mere possibility that an unnamed defendant may defeat a complaint at a later stage is not a legitimate basis to deny a Rule 26 motion that otherwise satisfies Rule 26's discovery standards. The district court's analysis also misconstrued the pleading burden at the Rule 12b6 phase. The court maintained that Strike 3 would need to engage in far more intensive discovery, sufficiently establishing defendant did the infringing in order to state a plausible claim. At this stage, however, a plaintiff need not set out all of the precise facts on which the claim is based, nor must the plaintiff prove its ultimate claim. To the contrary, even if it strikes a savvy judge that actual proof of the alleged facts is improbable, and that a recovery is very remote and unlikely, the judge must accept the complainant's well-pled allegations as true and draw all reasonable inferences from those allegations in the plaintiff's favor. So we got clarity on it. The court does not agree that Strike 3 is not made the showing. The court says that Strike 3 has made sufficient pleading at this time to get their subpoena. In this case, Strike 3 asserts that it has used a combination of forensic and geolocation technology to tie a single IP address registered to a user in the District of Columbia to 22 acts of infringement on specified dates over the course of a year. Based on these allegations, a court could reasonably infer that someone with prolonged, continuous access to this IP address was responsible for the alleged infringement. Viewing the allegations in the light most favorable to Strike 3, we think it, at the very least, plausible that the registered IP address subscriber actually did the infringing. So their standard is plausibility that the registered IP address subscriber actually did the infringing. Amicus contends that the district court's reasoning was correct because there is an obvious alternate explanation for the John Doe's alleged conduct, that someone else with access to the IP address in question committed the alleged infringement. It is undoubtedly true that individuals other than the IP address subscriber may have been responsible for the infringement at issue. On these facts, however, we do not find this alternate explanation to be so obvious as to render Strike 3's claim against a subscriber facially implausible. For similar reasons, Amicus's reliance on the Ninth Circuit's Cobbler, Nevada decision is misplaced. In Cobbler, Nevada, a copyright holder's complaint against an IP address subscriber was dismissed under Rule 12b6, but only after the plaintiff was permitted to subpoena the defendant's ISP. Indeed, the district court in Cobbler, Nevada granted the plaintiff not only leave to issue its subpoena, but to depose the subscriber once he was identified. This preliminary discovery revealed that the IP address was registered to an individual who operated an adult foster care home where numerous residents and visitors had access to the same internet service and IP address. After these facts came to light and the plaintiff failed to plead any additional facts linking the defendant to the alleged infringement, the case was dismissed. Under those circumstances, the Ninth Circuit found the defendant's status as the registered subscriber of an infringing IP address, standing alone, does not create a reasonable inference that he is also the infringer. Here, by contrast, Strike 3 has not even been able to gather such threshold facts about the alleged infringer. To be sure, the requested discovery may ultimately cast doubt on Strike 3's claim against the IP address subscriber. For example, the subpoenaed records could reveal that the IP address is associated with a coffee shop, a public library, or a residential facility where numerous users access the same internet service. At that point, if Strike 3 Holdings is unable to plead additional facts tying the registered subscriber to the alleged infringement, the scales may tilt towards implausibility. At this stage, however, we cannot know what Strike 3 subpoena will uncover. The mere fact that discovery may demonstrate that the subscriber is not the proper defendant is no basis to close the courthouse doors before Strike 3 can step inside. Finally, the district court's opinion implied that its perception of Strike 3's films may have colored not only its assessment of the Rule 26 motion, but the merits of Strike 3's claims. The district court explicitly stated that it would not accept the risk of misidentification in this particular context. This suggests the court may have taken a different view of the strength of Strike 3's allegations, but for its perception of the aberrantly salacious nature of Strike 3's films. For the same reasons set out above, the plausibility of a plaintiff's allegations against an anonymous IP address subscriber does not vary depending on the content of the copyrighted works at issue. On the allegations before us, we cannot conclude that there is no realistic chance the discovery Strike 3 sought will yield information relevant to its suit, or that Strike 3 will state a plausible claim against the IP address subscriber if the suit reaches the motion to dismiss phase. Because the district court's contrary conclusion was predicated on an error of law, we hold the court abused its discretion in denying Strike 3's Rule 26 motion. Lastly, we turn to the argument that the district court failed to afford Strike 3 the benefit of all reasonable inferences, instead relying on extra record sources, or outside the record sources, to question Strike 3's motivation in seeking discovery. We find the district court abused its discretion in this regard as well. The district court was required to assume the truth of Strike 3's factual allegations and draw all reasonable inferences in its favor. It failed to do so. It went outside the record and conducted an in-depth review of publicly available court filings, relying on this research to conclude that Strike 3 is engaged in a pattern of coercive litigation designed to extract shame in settlements rather than identify actual infringers. The facts before the district court did not support these conclusions. It is true that Strike 3 has filed 2,000 copyright lawsuits in courts around the country in 13 months. Strike 3 does not dispute it. It argues, however, that the volume of its litigation is dwarfed by the scale of the infringements it faces. It maintains that although its films are among the most pirated content in the world, it has pursued less than 1 out of 1,000 US-based Strike 3 infringers. Strike 3 further contends that no negative inference can be drawn from the fact that many of these lawsuits settle or otherwise do not proceed beyond the initial stages of litigation, given the established principle that the parties are free to settle their disputes on their own terms. Amicus argues that Strike 3's litigation conduct across a large volume of cases and its consistent pattern of never pursuing any case to judgment on the merits provides ample basis for the district court to infer that Strike 3 sought discovery for a reason other than defending its copyrights. According to Amicus, the district court acted appropriately in exercising its authority to take judicial notice of Strike 3's litigation pattern, and in relying on that pattern to infer that Strike 3 seeks hasty settlements rather than successful litigation. We do not dispute that district courts may properly take judicial notice of proceedings and filings of other courts. A court, however, cannot reasonably infer that a plaintiff lacks a legitimate motive in pursuing discovery based solely on their litigation volume and case history. While the district court did not explicitly refer to Strike 3's litigation conduct when analyzing its Rule 26 motion, the court's perception of Strike 3's motives appears to have colored its analysis. Indeed, the court took pains to emphasize that a different result might obtain in a case involving an honest copyright holder, and derided Strike 3's feigned desire for legal process in summarizing its holding. The factual record did not support the negative inferences drawn. We therefore hold that the district court abused its discretion by failing to apply the appropriate legal standards to Strike 3's complaint. For the foregoing reasons, the district court's denial of Strike 3's motion for a subpoena must be reversed. The district court's decision to dismiss the complaint without prejudice was predicated entirely on its denial of that motion. Because we find that the district court abused its discretion, the dismissal for failure to state a claim is also reversed. While we do not lightly intercede in a district court's management of its discovery process, this case presents the rare circumstance in which the district court exceeded its substantial discretion. We therefore reverse the district court's order and remand for further proceedings consistent with this opinion, so ordered. And I guess we'll get to see what happens in Judge Royce C. Lamberth's courtroom when Strike 3 takes this case back down to the district court level. I think there's an entirely realistic possibility that Strike 3 will simply dismiss this case, and we will get no further ruling. Strike 3 was given such a giant win here that they don't need this one case anymore. They've got this ruling Now they have carte blanche to continue to file these cases the way they've been. They don't even need the Florida Pure Bill of Discovery anymore, but heck, they get so many defendants' names there, so much cheaper. So congratulations to Strike 3 Holdings. Sucks for John Doe defendants, especially the innocent ones, and I guess I have a job for the foreseeable future. So let us know what you think in the comments below. Are you happy that copyright trolls will continue to be able to enforce this what I consider unequal copyright statutory damages regime against defendants in such a way? Let us know in the comments below. All right, that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel on YouTube, Twitch, and Floatplane. This is a community-supported channel. We would not exist without your financial support on a monthly basis on patreon.com/ljfrench and sponsors.com/law. Special thanks in the month of July to BU1 Simmons for supporting our channel. Thank you to our July $50 plus supporters: Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn, Abel. And thank you to the July $5 plus supporters who are in the description of the video below. I love you all. I really am thankful for all of your support. We really would not be able to do this without you. Have a good one. I'll see you hopefully next time from Luxembourg. Bye. Ah, get it off. I hate this wig so much.